share the paper and equally record. So I would like to state the following preliminary issues. That this is my personal experience. You see, CLE bar exam, I would say that it is the most overrated exam. But anyway, it deserves the respect. So you will understand, you will have to read a lot. But what you will be asked to answer will be maybe a small percentage, even a quarter of what you have read. So, and worst of all, it is the kind of pressure that we normally experience while preparing for these exams, especially for you who will not have the time that we had. But I can tell you for a fact, even right now, the time that you read for these exams are those 2 weeks after you see the timetable. That is when you will read. So right now you'll have coffee here and there. You'll go out kidogo. Okay, you will read. But the time for cramming, those final 2 weeks to exams are really, really crucial. So, and right now, if some people are trying to tell you that they are almost completing their coursework, revision, I would advise maybe you would decide to even hide yourself from some people because it can really, really discourage you in your pursuit. So just take it easy. Maybe we will have some time later. Julian, have you started recording such that I can begin?
Yes, maybe you can confirm on your side if you can see the paper and also
Yes,
that
yes,
this
yes, I
and the
can.
recording.
Yes, I can confirm that the recording is has started and the paper is also showing on my screen.
Okay, thank you.
Okay, thank you very much. So if some people are telling you that they are done with studying, that is a lie. Okay, so just hide yourself. This is something that you can do. Okay, so we will begin with question one. That is where we'll spend a significant amount of time. But the questions therein, they are just straightforward, so we'll be able to tackle them as we go by. So now, maybe you can do the honors, Honorable Otieno, Julian. Read for us question one. Start us off.
Okay. Question one, as a student in the Advocates Training Program at the Kenya School of Law, you double up as an intern at the law firm of Onyala, Biosi and Company Advocates. The law firm is based at Shule ya Sheria Plaza, ground floor along the Langata South Road in Nairobi County. The law firm's email address, that one. Then Fumo Liongo, a client has come into the office and you are assigned to take instructions from him. He gives you the following information. On 9th On 9th August 2022, he was going to vote in the general election at Westlands Primary School. Having alighted from a matatu that he had boarded from Kangemi to Westlands, he had to cross Wayaki Way to get to the polling center at Westlands Primary School. While crossing at a duly designated and marked pedestrian crossing point, motor vehicle registration number UBA 007M, that is registered in the neighboring Republic of Uganda, drove so fast as if from nowhere and knocked him down, causing him multiple injuries. The police abstract in his possession shows that the owner and driver of the motor vehicle was one Kaidundu Sempebwa, a Uganda national who was visiting Kenya for a conference. Sempebwa's statement with the police at the nearby Parklands police station indicates that at the time of the incident, he was rushing to Kulashiba Hotel along Mombasa Road for a conference. The address on the said statement is PO Box 35 Ginger. His email address is also provided as follows: ksembebwa@gmail.com. Medical reports from Ponakaraka Hospital in Parklands area, where Fumoluyongo was treated for 4 months, show that he suffered a broken leg, a broken arm, as well as multiple bruises on the head and the stomach. Receipts in the possession of Fumo Liongo show that he had already spent 2.5 million on medical treatment. The doctor the doctor projects that post discharge medical reviews and procedures will cost Fumo another 500,000 Kenya shillings. Your research on relevant case law for similar injuries shows that the expected compensation for pain and suffering and loss of amenities is in the range of 3 million to 3.5 million. This is by virtue of recent awards by courts in similar cases. FUMO's greatest concern is that the criminal proceedings in the traffic case that Mr. Sempebwa has been facing from this incident comes from judgment in 2 weeks' time. By law, the exhibit motor vehicle has been at the Parklands police station will be released to the accused after 14 days from the date of judgment in the criminal traffic case. Mr. Sempebwa will certainly drive the said vehicle back to Uganda. Mr. Sempebwa has no other propriety interest in Kenya and he ordinarily lives in Uganda. His presence in Kenya on 9th August was purely for conference attendance, and his subsequent presence has been to attend to his traffic case. FUMO is therefore concerned that whatever compensation that he may be awarded by the courts against Mr. Sempebwa will not be realizable in execution unless the motor vehicle UBA 007M remains within the boundaries of the Republic of Kenya. You have just briefed the managing partner of the firm, Mr. Onyala Biosi, who in turn has instructed you to prepare a draft letter of demand together with draft pleadings and a draft of necessary application that addresses Mr. Fumo's concern on execution of any favorable judgment that may arise from this case as expressed above. You have a reputation for generating impeccable drafts at the office. So A, prepare the draft demand letter, it's 5 marks. B, prepare the appropriate draft pleading for this case, 8 marks. C, prepare a draft of the necessary application that will address Mr. Fumo's concerns on execution as expressed in the instructions, 7 marks. Yeah. I'm done.
Okay. Thank you, Julene. Makofi. Clap for her one. Again, Makofi. Thank you. Yeah, she has read the question well. So the next task now is upon all of us to see how are we going to tackle this question. I am working under the impression that you have been trying to go through this particular paper, such that because this is something that you can read more than once for you to internalize what the question is all about. So maybe we can begin with question number 1A, which is asking that we should prepare the draft demand letter. Can maybe someone take us through that number, please? Or how they should approach the same? Anyone? The order is that we raise our hand and thereafter we proceed accordingly. Anyone, please? Okay, we have 2 persons, Kishiru Ann and Mutemi Rita. So we'll go with Ann and then Rita in that order.
Hi, good evening. So for the first part of the question, I'm not so sure, I'm just giving it a shot. On the preparation of a demand letter, I think what I'd do, I'd really be conscious of the contents and rather what goes into the demand letter. So for the first thing, I'd please scroll down the question a little bit. So yeah, so I'd start with how the demand letter is drafted. Since it's a letter, of course, we need to have the name and the address of the advocate, client, both advocates, the one who's receiving and the one who's sending, and also the letterhead of the law firm, as well as the authority of the advocates to represent the client, where the advocate says that he's been mandated to represent the client, as well as the facts, and also whatever that is being complained of. So after stating whatever that's being complained of, I'd then expound on the relief being sought and also the time that the other party is required to comply. And then I'd give the results of not complying. I mean the consequences, sorry, and also I'd authenticate it with a signature. So I don't know if I should go deep into the relief sort, or the next speaker can maybe go deep into the relief sort.
Maybe you can proceed and tell us what do you mean by the relief sort, please. Yes, Anne, please proceed. Maybe go deep to the relief sort.
Okay, just a moment. I'm trying to open the question on my end, and it's taking a little bit of time. Can the next speaker kindly go before me as I sort out my word in the interest of time?
Okay, thank you. Thank you. Rita, take it away.
Okay, so I think Anne has discussed the contents of the demand letter. I do not know what I'm supposed to say, or I'm supposed to like now read what it's supposed to have.
Maybe give us your answer.
Sorry?
Give us your answer. That would do. No problem.
Okay, fine. So my answer, my demand letter will start with the letterhead, of course, Onyala Busey and Company Advocates, the address of that firm, and that letterhead will be at the middle. Of course, it depends on how you structure your letterhead, and then we'll go to our ref, your ref, and then now the date on the same line. And then after that, and then now I will write the addressee's address now, the defendant's address. And then after that now, dear sir. After dear sir, my reference will read, or my subject line will be claim for damages on personal injury by you in the sum of 3,400,000 Kenya shillings. That's how my subject line will read. And then now the next, the first paragraph is under whose instructions we are acting. Of course, it's Mr. Fumo Liongo, our client. And then I'll proceed to give a brief summary of the facts in this matter. Then after that, I will go to, as a result, of course, of the defendant's negligence, our client has suffered loss as follows, and then I'll list them. Of course, the damages our client has suffered. And then after that, now the relief sought. So then I will be specific, because we are told that it's a range of 3,500,000 Kenya shillings. So maybe I'd have my sum, according to me, my sum will be 3.4 million. So from our assessment, something like along the lines from our assessment, based on the relevant case law, the expected compensation for pain and suffering and loss of amenities is in the sum of 3,400,000 Kenya shillings. And then I'll go to the last paragraph, which is we demand that you compensate. Our instructions are to demand that you compensate our client a sum of 3,400,000 Kenya shillings. Yeah, and then you tell them if they do not comply with against this defendant, and then I'll sign off. Yours faithfully, my name, and then my the firm, my firm's name, and then I will CC my client, who is Fumo Liongo. I'm done.
Okay, thank you so much, Rita. Thank you so much, Anne. I will go to the last person such that I can now give my concluding remarks, because all your answers are correct. Janita, maybe you have something to add before we proceed.
Yeah, so I just wanted to add on, like, for the relief, I think it's important to be very clear in the demand letter what you're asking for. So probably just to add on, I would just to Anne's point, I would say the relief I would ask for is compensation for pain and suffering at the sum of 3.5 million and 3 million for the cost of the treatment due to the injury. And yeah, that's it.
Okay, thank you. Winnie, please mute. Muluki, Winnie, we can hear you on our side here. Okay, guys, let us clap for these three contributors. They have done a great job. Very well, very well. Thank you so much. Thank you so much. So, guys, you have heard what our colleagues have stated and what their views are with respect to this particular question. We were lucky. So it was straightforward. And if you have written a demand letter or two, then you realize that was something that was straightforward. We were not expecting it. So maybe you guys too will not be expecting it. We don't know. So it is not like a CSU exam when you say that maybe they will not repeat. So by they have that tendency whereby they can repeat questions from now and then. So what you have to look at keenly on questions like this one, and even the next one that we will look at. So look at those email addresses, those dates. They are very crucial because they will assist you in drafting your pleading, or let's say a demand letter. So you have at all time, if someone had asked you to draft a demand letter, please try to film it, draw something, okay, make it beautiful. Okay, not beautiful like you, but try to make it beautiful, and then go and describe it the way it is. Our reference should start there. Your reference, most of the time it is TBA, to be advised, or how is it, something like that, and then the date, it is always on the same line. Okay, so the one thing I can mention in this particular question are those salient features in a demand letter. It is a question that can come in legal writing and drafting. It did not come during our time. Okay, I remember we wrote a lot of letters too, but it can now come in an examination setting. Someone is going to ask you to describe or to explain at least 5 salient features of a demand letter. Okay, such that now you can have the address, you can have your topic, the introduction, you can have that place that they put like some kind of history, although it doesn't form part of it. You have the demand, okay, the timeline, and where you are going to sign off. Please go and study, find out what are those salient features, those 5 salient features of a demand letter. Are they 5 or 7? It is something that you can find out because it's an examination question. So you are lucky. Something that you learn in LWD, it actually comes in legal in civil litigation. Okay. So I can see someone has raised their hand. I was hoping to go to the next one. Yes, Mr. George. George, you can unmute. Time is not on our side. Onyango George, you have raised your hand.
Yes,
okay.
Can I be heard?
Yes, I can hear you now, but it is like you have 2 devices.
Okay. Fine. My question is.
Yes, sir.
My question is that because this is a case that involved a case of 2 nationals, the Kenyan and the Ugandan. On the demand letter, you give the 7-day or 10-day or the 15-day duration.
Thank you for that question. you see, we have been given where he's staying for now. It is some hotel along Mombasa Road. And that is going to be his address for now, okay? So since he's not out of the country, remember he's still handling his criminal matter, okay? So 7 days will do, okay? 7 days will be sufficient.
Oh, thank you, thank you.
All right. So that is it on this particular question. And then I had two speakers saying that address of that farm. Please remember and be keen as well, because here it is not the farm that you'll be writing that demand letter to. So it is this particular individual, this person called Chandundu. Okay. It is not that I have pronounced it bad, but like Chagulanyi, Bobby Wine. So Chandundu, Sembe, okay, that one. So you are writing to an individual, so you are not writing to the farm. So before we proceed, by the way, CLE are always intentional, okay? In the sense that sometimes what they want you to answer is given to you. For example, you have been told you have just briefed the managing partner at the farm, Mr. Onyala Biosi, who in turn has instructed you to prepare a draft letter of demand together with draft pleadings. So you will see in subsequent question, the question will always be close to the final one, such that you don't go and answer your own things, okay? Finally, as we go to the next one, someone has raised their hand. Yes, Priska.
Yeah, the address that has been given is actually the one for Jinja, Kampala.
Mm-hmm.
I mean Uganda, because this other one for Kulashiba around Mombasa Road is where he was rushing for the conference. But the address that we've been given, we've actually been told that his address is a PO Box 35 Jinja, and his email is that one at Gmail. So I've heard you saying that we'll address it to the hotel. Or which address are we supposed to use?
I agree with you, but where he is staying for now, of course you will put this one as his PO box, but it is not going to determine the number of days that you are going to give him, because he's not out of the country. He's in Nairobi.
Okay.
Okay. So it doesn't make a significant change. So the purpose of this address, it was given to you such that you can include it in the address of the recipient. Okay?
Okay.
Yes. But the guy is in Nairobi.
Okay.
Okay?
Yeah.
Can we have the second person to take us through question number B, whereby we have been requested, okay, not a request really, but to prepare the appropriate draft pleadings for this case. What are we drafting? Someone quickly, please. Chap, 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 chap. Take it away, Bwana George.
Oh, okay. What we are drafting here is a plaint. And in the plaint, I think I'm still doing my computations to ascertain the court at which we should file our matter, but I'll stop it at that.
Okay, thank you. Anyone else? Who will now take us through the plaint? We have now learned that what we are supposed to draft is a plaint. Another person, please. Inueni mkono. Okay, Rita, please.
Okay, I think I can give it a try. The plaint will start with, is it called the caption? Republic of Kenya in the Magistrates Court in Nairobi, civil suit number dash of 2023, and then we'll have the parties, plaintiff against the defendant, and then it will be a fast track plaint. Then the first paragraph gives information or describes the plaintiff. So the plaintiff is a male adult of sound mind residing in Nairobi within the Republic of Kenya. And then, of course, the plaintiff is being represented by advocates. So you say his address for service for the purpose of this suit. I think, I'm not sure about that, for the purpose of this suit will be, and then now you'll have the what is it called? You'll have the address of the law firm representing him. And then the second paragraph, of course, describes the defendant. And then the third one now, that's where you start with the facts. The facts of this case, and then you can have the third paragraph giving the facts, and the fourth, and then now on the fifth you will have the particulars of negligence. So for example, mine will be driving motor vehicle registration number UBA 007M in excessive speed in the circumstances. And then the second one will be failing to keep proper control of motor vehicle registration number UBA 007M. And then the third one maybe will be causing the accident. And then after that, now, as a result, now the sixth paragraph would be, as a result, the plaintiff has incurred the following damages. So I'll have the particulars of damages. Maybe I'll categorize them. We have general damages and special damages. So for special damages in this case, if I look at the question, medical treatment, which is 2.5 million, and then medical review, 500,000 Kenya shillings. And then the seventh paragraph, we have I think it will show that the plaintiff has demanded or has made a demand that the defendant compensates him, but the defendant has not. So maybe, for example, I'll say, despite demand and notice of intention to sue being issued, the defendant has failed or refused to admit liability, hence now this suit. And then the next thing will be now the matter. No, that's the eighth paragraph, res judicata. So that there's no pending suit as relating this matter or no other previous proceedings, of course, that relate to this matter. And then the next paragraph now will have will show that the court, that particular court you're submitting or you're filing the plaint in, has jurisdiction, so that the cause of action arose within the jurisdiction of this honorable court. And then now prayers. So for prayers, I think they start with for reasons wherefore the plaintiff prays for judgment to be entered against the defendant for. So you seek general damages, specific damages of 3 million Kenya shillings, and then the costs of this suit. Then now, this part, dated at Nairobi, this 5th maybe day of September 2023, and then you'll have the advocates representing the plaintiff there. So Onyala Biosi and Company Advocates at the middle, just after dated at Nairobi. And then now drawn and filed by Onyala Biosi and Company Advocates, and then it's supposed to be served upon the defendant. Yes.
Okay. Thank you so much. That was really great. I'm impressed. So Orina and then Kibi. Maybe we'll have those two, and then we move to the next number. Orina?
Thank you very much. I agree with what the previous speaker said, save that I would add that the second paragraph, the first and the second paragraph, in the plaint are for the service of some the address or the address of the plaintiff and the defendant. That is the first paragraph addressing the address of the advocate of the plaintiff, and the second paragraph should provide for the address of the defendant. And in most cases, we provide that the service of summons shall be through the plaintiff's advocate. I think that is the second paragraph. And yes, I think after we have drawn this plaint, it will be prudent that we draw the verifying affidavit for the plaint. Thank you very much.
Okay, thank you. Thank you so much. Thank you. That was really, really great. Kibi?
So, okay, in addition to what Rita said, I think another paragraph I'd have is that after explaining now how the cause of action arose, we'll have a paragraph enumerating the injuries that were suffered by the plaintiff in this case, because I think in the question we have been told that they suffered an injury on the leg, bruises. You enumerate them in a paragraph, and also there's a paragraph on liability. I don't know if she mentioned, but I think you need to also say that the plaintiff blames the nini or states that the defendant is all liable fully for the accident that occurred.
Very well, very well, very well. You see, that is the whole plan that we have just tackled in just under a few minutes. But the question is, can you now draft that plan using your pen and your paper? To draft it in a computer is one thing, but drafting it from your head, let's say in a piece of paper or in your notebook, is another thing. Let me hear what Priska has to add, such that we can move to the next number.
I wanted to take you through the verifying affidavit.
All right.
Okay, so after we've drafted the plaint, the plaint is not complete unless it is accompanied by the verifying affidavit. So we'll have the caption as stated in the plaint. That is Republic of Kenya in the Magistrates Court at Nairobi, civil suit number that of 2023. Then we'll have Fumo Liongo as the plaintiff, then versus Kayundu Semwambwa as the defendant. Then after below that, then we'll have the heading of verifying affidavit. And then we'll say that I, Fumo Liongo of PO Box this of in Nairobi, Kenya, hereby make an oath and state as follows. Then 1, we say that I'm a male adult of sound mind, and the plaintiff herein hence competent to swear this affidavit. Then the second paragraph would read like that: I have read and understood the contents of the plaint herein drawn on my behalf by Onyala BOC and Company. And after the same being explained to me, I confirm and state that the averments therein are correct. Then the third one would be that there is no other pending suit, and neither have there been other previous suits in any court between the plaintiff and the defendant over the same subject matter. Then the fourth would be that I swear this affidavit in support of my plaint herein, and that what is stated herein is true and to the best of my knowledge, information, and belief. Then after that, you will swear it. So sworn by the said Fumo Liongo at Nairobi on this date, 2023. Then before me, hapo chini, Commissioner of Oath. Then you underline. Then you will sign. You will depone it on the right side of the page, like how we normally do it. Yeah. Thanks.
Thank you so much. Janita, you have something to add?
No, I just have a question. So after a close look at the question, it says the draft. I mean, it says prepare the appropriate draft pleading. So in a draft, do you really need a verifying affidavit for this? Or is the plaint enough?
Okay, that's a good question.
Okay, maybe
You see, a plane cannot go alone without a verifying affidavit. So it doesn't matter whether it is a draft or not. It is just that you see you are an intern there or something like that. So at the end of the day, you will submit those documents to your supervisor or pupil master. So, and you cannot submit a plane alone without the accompanying verifying affidavit. And at the same time, by the if you will come out later in practice, it is not always those two, because you can also submit the same with list of witnesses. You can submit with your list of documents and even witness statement. But for the examination setting, for example, like us, what we did, we just drafted our plane and the verifying affidavit. Okay, we thought that was sufficient at this date. And you will realize there are those that are really crucial, because not all the marks will go to the content of the plane as it is, because caption is really important. You see, when Onyango stated that he was not sure the court at which he's going to file it. Okay, because that one, it will mean that you have to look at Section 7 of the Magistrates Court Act. Is it above 20 million? Say that you can go to the High Court Civil Division. Okay, if it is 20 million and below, okay, then it means that you will file it in one of those magistrate courts. Okay, so then the caption, it always has like about 2 marks. You have to write the parties well. What is the track of your plane? Okay, have you put in place accordingly the description of the parties? Okay, how do you now begin to give your background? Okay, at all material times, what happened? What was the status? You give the background. What was the particulars of negligence? The particulars of loss, or you can say stroke. For example, in this case, they are injuries. You put them together. What are then the particulars of damages? Okay, you put them there. A statement to the effect that the aspect of res judicata. Okay, very, very important, the jurisdiction of the court. You cannot leave that one. And then now you come to your prayers. There are marks there. Then you come to your jurat. Okay? And then thereafter you will be done with your plane. In your verifying affidavit, you don't need to repeat the caption again. You can just state caption as in plain, because by the way, time is very, very, very limited. Okay? Time is extremely is of essence. So you have to move with speed. So that is it. We have spent a lot of time in this question. If someone please allow me so that we can go to question number C. Is that okay?
I have a question.
Okay, who is that?
George.
Okay, Bwana George.
I'm very keen on the caption, most of the court at which we are supposed to file our matter, because the presenters just said the magistrate court. Which magistrate court?
I will tell you for a fact, please, in an exam, especially for this one of CLE, don't go to the divisions as such. Just write in the Chief Magistrate Court at Nairobi, civil case number, okay? Me and you, or we all know this is supposed to be civil division, but remember, those courts, there are some divisions that are there, but it is good that you just maintain that it is Chief Magistrate Court. Don't say it is principal or resident. No, just say in the Chief Magistrate Court. That would do. Is that okay, Onyango?
I'm well guided.
All right, thank you. Who is this? Julie Otieno, are you the one taking us through question number C? Your hand is up.
Okay, not really. I just wanted to help answer Janita's question. In addition to what you've told us, our lecturer this week had told us that in an exam setting CLE, if they tell you prepare the appropriate pleading, you're not, if it's a plaint and everything that accompanies a plaint. But if the question, let's say, says prepare a plaint, he told us that you don't have any business preparing the others. Like you're just supposed to conform to, like, to just write the plaint as it is. Do not now go, because the marks are in the plaint, not everything else that is accompanying it. But when it's a pleading or it's an application, that the question is just as general as it seems, you're supposed to draft that pleading and every other thing that accompanies it. Yes, that's what I just wanted to add.
Okay. All right. Thank you for that. So guys, let's clap for everyone who has contributed to this question. Makofi bwana. Asanteni sana. Aya, who is taking us through question number C? Time is running really fast, but I believe we will make it. Awur. Tesa sasa.
Yes, hello. So question number C, prepare draft of the necessary application that will address the concerns of Mr. Fumo on execution as expressed in the instruction. I am suspecting we will do a notice of motion application for the defendant in this case to furnish security for appearance, and that NOM will be accompanied by a supporting affidavit. Yeah.
Okay, Awur, I hear you, but I was expecting you to maybe go further. We understand that we are supposed to draft a certificate of urgency. We are supposed to draft a notice of motion application and a supporting affidavit. Do you have anything that you would like to add?
No, I think I'll pass it to, there's a hand. I think there's some assistance.
Okay, thank you. All right, whose hand is that? Alice Njero, kazi kwako.
Okay, I will continue. So for me, I thought that we are going to draft a notice of motion, yes, but we will be seeking the prayers of arrest and attachment before judgment, because we've already been told that he's here for the hearing of the criminal case, which is almost over within 14 days. So we will need to seek an order of attachment of the motor vehicle UBA 007 pending the hearing and termination of this suit. So under the notice of motion, I would quote Order 39 of the CPR and Section A1, 1A, 1B, and 3 of the CPA 2010. And my second prayer would be that this Honorable Court be pleased to issue an order of arrest of the respondent pending the hearing and determination of this suit. This is probably because the motor vehicle will not be sufficient to cater for the damages that we are looking for, which is about 6.5. So I would think that if this person is arrested, then it would furnish a security, which would suffice for the payment of the decretal sum. Then after that, I would seek costs of the application. And then I'll go to my grounds, which would be that the respondent is not a Kenyan resident, so it is very important to arrest them before the hearing and termination of the suit. And also I would talk of the necessity of attachment of the motor vehicle UBA 007M, which is already within the jurisdiction of Kenya, because it is likely that the respondent will probably take it back to Uganda. So those are my grounds. And then I would talk of the application will be further supported by the supporting affidavit of our applicant, who is Fumo Liongo, and consequently I will date it at Nairobi this day and all that. Then I'll go to drawn and filed by to be served upon. And then finally, I'll draft my supporting affidavit. That is all.
Okay, thank you. Thank you so much for your contribution. Let me hear what Orina has to say. His hand is up.
It's my hand.
Thank you very much. I was okay. I concur with what the previous speaker said. We do not need the. I think but I would like to say that we do not need an arrest order, but we need the Mareva injunction. That's the freezing order to ensure that the defendant does not remove the motor vehicle from the jurisdiction of the court. I agree with the previous speaker of saying that we go under order 39 for the Mareva injunction. Thank you.
Okay, thank you for that, Rina. Now, Priska, you can proceed.
Actually, I thought this was a Mareva injunction because this person is, the client is worried that after 14 days, this person might leave the jurisdiction. So that's why we should go under certificate of urgency. Then we go for the Mareva injunction orders and a notice of motion. So I agree. But also, I also agree that there's no need for arrest as this is a civil case. And yeah, there's no need for arrest. Thanks.
Okay. Thank you for that. So now you see.
I have a contribution.
Okay, please proceed.
Yes, I would like to defend my point on the order of arrest because it is very likely that a motor vehicle is something that is going to depreciate, and we do not know what we can fetch from the motor vehicle. So my argument was from the decretal sum that we might get, the motor vehicle might not be able to fetch that much. That is why I was thinking that because it is important that we have this person arrested, and if the person is arrested, it is very likely they are going to give security for the decretal sum. So that was my argument in line of the arrest.
Okay, thank you. However, although I agree with you, but you see what you are seeking, an interlocutory order. Okay, you realize when it comes now to the conclusion of the suit, when it now becomes a money decree, that is when one of the things that you will seek is an arrest. Okay, but for now, I think it is too early for you to. Sorry, I was muted. Yeah, I was saying that in this application, you will not apply for him to be arrested as of now, because you realize that your interest is that particular motor vehicle. You see, that is why sometimes it is important that you look into the question, because what you're saying that unless the motor vehicle UBA 007 remain within the boundaries of the Republic of Kenya. I agree even with the aspect of people who are talking about the aspect of Mareva injunction. It is still okay. Okay. But if you'll have access to maybe the best student, I don't know. Okay, she was the best student. I don't know if it is a she or he. He or she did not focus much on whether it is a freezing order, which I believe it is, or whether it is just an interlocutory application. Okay, an interlocutory injunction. Personally, I went with an interlocutory injunction. That is a temporary injunction. Okay, I look at the back of my mind, Giela versus Casman Brown. Okay, but what is important is, let's say, for example, in your certificate of urgency, How do you begin? There are also marks for the caption. Like I told you before, content, yes, there are marks for that. But how is this particular court paper appearing? Is it in accordance with the rule? Okay, your certificate of urgency. How have you begun that particular certificate of urgency? Because you realize from that certificate of urgency, it will even make your work easier when you be drafting your notice of motion application and your supporting affidavit. Okay? Have you started, Angelo Sijui so and so, an advocate of the High Court of Kenya, duly instructed, okay, by so and so, whereby I certify this one as extremely urgent for the following grounds. I have given my grounds. Or have I just finished my certificate of urgency at some point and I have not enumerated my grounds? Okay? Then in your notice of motion application, they want to see you have not begun late so and so. You have got take notice that, because it is equally important. So remember, certificate of urgency, you have your caption. Your notice of motion application, you are supposed to have your caption, but because we are in an examination setting, you don't need to repeat that particular caption. Just proceed caption as in certificate of urgency. Okay, what are the orders are you seeking? Okay, it is one thing for us to know, but what are the orders that we normally seek in this particular application? Maybe we have 4 of them, whereby the first one should be that this application be satisfied as extremely urgent. And you can even add and service be dispensed with. Okay? Then your number 2 should be that this honorable court be pleased you to do what with this particular motor vehicle pending the hearing and determination of this application. That is 1. Then your order number 3 should be similar to that order number 2, but now it will be pending the hearing and determination of this suit. And then now you pray for the cause. Very, very important, at least 4. Which application now should be based on the grounds, the following grounds, whereby you are supposed to also state them in your notice of motion application. Okay? And then now you proceed to your supporting affidavit. Okay? I believe we all know how our supporting affidavit should look like. Okay? In this regard, you realize those who might have cited Order 39 might have had higher marks than those of us who maybe relied on Order 40, Order 51. Okay? So as long as you have that knowledge on how a temporary injunction or interlocutory injunction should look like, then you are good to go. So the CLE were actually not unfair to us, considering the marks that we have been given, 7 marks, and you are drafting 3 documents. That was really, really unfair. So I can see Anyona Oscar, you have a question? Because I would like us to go to question number 2.
Yeah, okay, thank you. Before we go to question 2, maybe just to explain why you received lesser marks than those who relied on Order 39. I've had the benefit of going through the recording, which was recorded by Solonka, Revision Civil Litigation last year, I guess. So he tried to differentiate Order 39 from Order 40. That's to say attachment and arrest before judgment and injunctions. And they actually said, or rather he says that Order 39 on attachment before judgment applies when the property is being removed from the jurisdiction of the court. And then anything to do with selling of the property, attempts to waste the property or destroy it, you approach the court seeking orders for a Mareva injunction. So then in this instance, because we are told that the property is not in Kenya or something of the sort, is in Uganda. So for that case, then, yes?
The property is in Kenya, but the fear is that it might be removed upon completion of the criminal case.
And then, so because there's that fear or that concern of being removed from the jurisdiction of the court, then Order 39 on attachment before judgment suffices.
Yes.
Yes. Thank you.
Yeah. So that is it is actually in that aspect. But you see, the problem is when you go to that particular exam, and I don't want you to be afraid. sometimes some things will just decide to disappear voluntarily, not by force, but they will just say, you know what, Angelo, this is where we part ways. Okay, very, very wrong. But you just have to survive through. Okay, so just write whatever you know. By the way, when you see the best student, I know this is being recorded, you will not understand how, but she was really awarded. I don't know why I say that is she, because the guy, her writing is really bad. Even mine is better, but the the issue is just right. I have the words and writing, but this one. So just try to write whatever that you know. Okay. For example, on the aspect of verifying affidavit, you will note that maybe somewhere it has been written that you don't need to write a verifying affidavit. But what I can assure you with CLE, or what I have learned through my training, is that no one is going to punish you because you have written something. You will be penalized for having not written something. Okay? Just write, the examiners, they are going to decipher whatever you have written. Okay? So don't fail to include what you are meant to include. Okay? So thank you guys for this particular question number 1. We are now up as 1:30. Barak, Kamire.
Yes, Angelo. I understand you said that maybe it's premature now to arrest him, but if there is a provision for arrest before judgment, does it cover Order 22? Because I would like to what the speaker was saying. I think that was a word or somebody.
Yes.
Of arresting, because if you look at Order 22, Rule 7, it says that this guy can be arrested if he can be seen within the precincts of the court. Only that in this particular case, there is the use of the term judgment data. But if you are looking at the fact that we can possibly effect judgment, I mean attachment before judgment, would you think that Order 22 Rule 7 might come in? Because I think that is where perhaps a word was alluding to, that this person can, if he can be seen within precincts of the court, an oral application can be made. Though I recognize that this is more so after the judgment, but in this particular case, what do you think? Is there a distinction?
Yes, there's a huge distinction, sir. And that is why I would sustain and maintain that you don't need to apply for that arrest before judgment. I don't think it is necessary. By the way, out here, let me tell you one thing. Judges and magistrates are afraid to confine someone to cell or prison or things like that, even in children matters. Okay? So if there is a remedy to that particular legal issue, then they will go for that one. Okay? Because you will realize even after, let's say, maybe you are successful in the orders that you are seeking in your notice of motion application, you will be asked not to leave the jurisdiction of the court. Okay? To arrest him now, I still don't believe. You can just cite your Order 40 or Order 39, Order 51. Okay? Esbon Oko, you are here? Okay, please let's try not to mix things up, because I believe one of the remedies that you have given us, we have a question for it in this particular paper. I hope we will have time. Let's go to question 2 very quickly. Someone can just read, someone who is happy, they are about to do CLE exams. They have read even the content for next year. Someone, please.
If I may, can you hear me?
Yes, I can hear you, but your names are like those one
Okay.
of the roots. Yes.
My name is Lewinsky Muhira. So let me proceed and read question 2. David Mungala filed a suit against John Doe, claiming adverse possession over all that parcel of land known as Ngong Block 1 47577. In March 2019, he obtained judgment and the court ordered John Doe to transfer the parcel of land to him. David never followed up the matter to have the land transferred to him. John Doe passed away in June 2020. Peter Doe, John's eldest son, who was away for studies in the United States of America, returned home and found David Mungala on the parcel of land. He obtained letters of administration and filed a suit against David, seeking to have him evicted from the suit land. David has raised a preliminary objection on the propriety of the suit filed by Peter on the ground that it is an abuse of the court process. The matter has been placed before you, and the parties have made their rival submissions on the preliminary objection. With the aid of decided cases, write a ruling on the preliminary objection.
Very good. This is a very, very nice question. A very beautiful question. I don't know if I had 10, but kama nilipata kidogo pia nashukuru Mungu. So guys, this is a great question, and it is trying to examine one thing, but I want to understand maybe how people are going to draft this particular ruling. Because like I said before, the structure is really, really important, as is the content, okay? As is the content. So those things always go hand in hand, because that is why we are at the Kenya School of Law. So let's have someone try to maybe draft for us a ruling in this matter, and maybe tell us what does this question really want? Very quickly, when I'm a summer idea 2025. Someone, please. Orina? Okay, Orina, go.
Thank you very much. We are writing, I will help in writing this ruling. A ruling, first of all, it is in relation to an application. Therefore, the caption will be the code, as per, it will be as per the application headline. So if the application is the Republic of Kenya in the ELLC code, in the ELC code, then civil, in the civil suit number, then application, then we'll talk of the ruling itself. The first paragraphs in the ruling will be the background of the story of the issue, background. Then we'll go to the issue. Then we'll now deduce the issues for determination. And then we will proceed to analyze the issues for determination. And now the court will give its orders as per the analysis that has done. So within the analysis, it is where we'll be having our case laws. For example, in one of the cases that I think we'll have is the Emrao case. Yeah. Then after the court has given the orders, then we will need to, then the judge issued the judgment. The order will need to, the judge who issued the orders will have to sign the ruling and date it. Thank you.
Okay, thank you, Orina, for that contribution. Anne?
Good evening once again. So yeah, for question 2, writing a ruling on the PO preliminary objection, first begin with, as Orina had said, is it the caption, the Republic of Kenya in the High Court of Kenya, let's say at Nairobi, and civil suit dash. I don't think I'd give the date yet, because from what I remember in class, we were told we can leave the number of the suit number blank, and I'd say it's between the parties, and describe the parties by giving the name. And then after that, I'd write a heading. I think it's the ruling, yeah. And then if my memory doesn't fail me, I think we'd start with number 1. You have to number, and you'll say that on the particular date that PO was raised, and in this case, it was raised on the following grounds. We'd say that on the grounds that it's an abuse of the court process, and then what would follow, I think it will be clarifying what a PO is. And from what I remember from the Mukisa Biscuits case, a PO should include a point of law which has been pleaded or arises by clear implication of the pleadings, and which, if argued as a PO, can lead to the disposal of a suit. And then I'd quote actually the case, and then after that, I'd refer to the issue of just a sec. Yeah, maybe I'd refer to a legislation in regards to the ownership of land and any other legislations regarding the same. And then what would follow is, I think, my decision, and if there is a dismissal, or if I'll grant a dismissal based on the PO, and whether it's a dismissal with costs or not. And then I'd sign off by stating when it was delivered and signed, my name, and then indicate my position as the judge. Yeah, that's what I'd do. That's how I draft the ruling, I mean. That's all, thank you.
Okay, thank you, Anne. Before Esbon comes, I will try to also brush through quickly, in the sense that there was one thing, for example, you see, like right now, you see it in the High Court of Kenya. I understand the Limitation of Actions Act as is yet to be amended, but issues relating to adverse possession, I would have liked it if Daniel was here, because he told us some time back that we should go to the High Court. It is supposed to be ELRC, okay, in your caption. So you don't say in the High Court of Kenya, but in the Environment and Land Court. I understand that particular act is yet to be amended, but all matters relating to land, they are handled by the Environment and Land Court. So your caption should read to that effect. Having said that, there are 2 things that the examiner wants in this regard. Okay? The ruling does not even have anything to deal with adverse possession, by the way. You are being tested on number 1, whether you will know what is required of you when you are drafting a PO, or what type of ruling should you write with respect to a PO. What is PO about? When or why are we required in the first place to write a PO? On what basis do we write a PO? And having said that, for example, if we say that we are raising this particular PO on a pure point of law, what is that pure point of law in this regard? Because you are not going to just write your ruling like that. We have to know what is that pure point of law. You have been told that David Mungala filed a suit against John Doe claiming adverse possession over all that parcel of land known as Gong Block 147577. In March 2019, he obtained judgment, and the court ordered John Doe to transfer the parcel of land to him. David never followed up the matter to have the land transferred to him. John Doe passed away, in June 2020. So you realize that a determination was already made in that said parcel of land. The only thing that has not happened is that Mr. John Mongala did not transfer the aforesaid parcel of land to his name. However, now we have this young man who just came back from the United States of America, Peter Doe. He now went ahead and filed another suit. Okay, this is when now David raised a preliminary objection. So what has happened there? There is therefore a point of law. Is it Section 7 or is it Section 6 of the Civil Procedure Act? That is something for you to look at. Res judicata. Okay, that is a pure point of law. So the examiner would like to see that when you are drafting your ruling. Okay, the examiner would like to see that when you are drafting your ruling. If you are drafting, let's say, a PO, what is this well-celebrated case that must be cited? Kisa Viscuit versus the West End, is it called what? Yes, that one. Your examiner would need to see that, that particular question. What is then the structure of this particular ruling? Do you have your introduction? What is the background? Okay. What are the issues for determination? What is then the determination on these issues or analysis? We call it analysis. Okay. And then now you'll proceed and give your final orders, and then you will sign. All right. So someone has raised their hand, but if not, then I can. Okay. Onyango, you have something to say? Because I would like to quickly invite Esbon to contribute before we proceed to the next number. Onyango, your hand is up.
Yes. Thank you for the opportunity. My points marinate with what Mr. Gisore has said. However, I have a concern. You have only talked of the case laws, but the necessary provision of the law based on the preliminary objection. Which laws are we relying on?
Come up again. What do you mean?
The laws, the provisions that we are relying on.
That we are raising a PO.
Yes.
I address that, Angelo, if you allow me to.
Okay, please proceed.
Thank you.
Thank you so much, Angelo, and everyone, and I hope I can be heard. So now I'm particular about this question, the question asking you to draft a ruling. So we can actually, first of all, just kill two birds with one stone by getting to know how to draft a ruling, and as well as the judgment, because you can either be asked to draft this ruling, or in other case, you can be asked to draft a judgment. So the only thing, or the important thing you need to know or to understand if you're asked to draft about a ruling or a judgment is to ask yourself, what are the deliverables for a ruling or a judgment? I'm really impressed. I've seen the earlier contributors from the students. They've really done quite well, being able to look at the spices, or rather the items that shall be contained in that ruling. And that is actually good. Of course, you understand that various judges have their own style of preparing judgments and rulings, and particular rulings. But for the purpose of CLE, you're just being tested on your understanding of the format or requirement of a ruling or a judgment. So for this particular one, you've been told that parties filed their submissions, and you've not been told of the contents of their submission. However, you've been told about the subject matter of the ruling, and that is actually relates to an issue of PO. So Angelo was already explaining to you that once you hear PO, then Mukisa Biscuits versus Western Distributors comes to your mind. And then so you as a judge, like it's expected upon you to know what you think was the issues that the advocates were actually discussing in their submissions. The advocates were maybe discussing that these are point of law, and maybe they based their PO on, they usually think 5 or 4 things which you base your PO on. And I have heard you mention 2, which is sub judice under Section 6 of the Civil Procedure Act, res judicata, Section 7 of the Civil Procedure Act. You can have also jurisdiction. You can have limitations of time. And then I don't know, I think there is a fifth one, just keeping my mind, but those are actually grounds that you can, the pure points of law that you can base your PO on. So that while writing the ruling, those are the things which can be brought by the advocate in their submissions. So the expectation of a marker in this question, basing on the facts, maybe they wanted to know, like, do you understand that maybe the suit was filed in a wrong court, so that the reveal submissions are discussing about you having filed a suit in a wrong court, or maybe they are discussing on you have delayed in filing the court, so in filing the suit, so that you're out of time. So those are the things that you will be discussing, so that the first part will just be the parties and the description. You discuss the parties, their representatives. Then you go to the second section. What is the applicant's case? The applicant's case is usually contained in the initial pleadings. Then what is the respondent's case? So depending on the parties, could be plaintiff, respondents. Then after there, you now look at the issues for determination. So issues for determination are actually defined by the issue you want to dispense with. In this case, you want to dispense with the issue of whether the PO is merited. And so that is the sole issue for determination as a judge, that the sole issue for determination is that one. Then you try end up in your position, like, what do you think the applicant will be submitting on? If they are defending that, if they're actually defending the motion that this suit is be dismissed by PO, then of course they're the ones who are actually mentioning those grounds. Then the other one trying to argue in favor of their own cases. And of course, try to come up with the case law like that one, the one you mentioned, and any other. Then yourself, you now submit, okay, having that issue and applying those issues to the fact you have, you just give a sound decision. You'll not be penalized on like it having to be a certain disposition. No, as long as it's just sound. Then there are also other key important things. Remember, I don't know if you've covered judgments in your various classes, but there are some of the issues that a judgment must have. For example, who should give judgment, how is it dated, issued, signed, and everything. So you ensure all that it is actually done. And then you also remember to sign. Sign as a judge, ensure you sign that ruling. So once you have all that, then I think you'll have all the 10 marks required for that question. So I'm sorry I've taken much, but I just wanted to ask to cover it also, that in any time we receive a ruling, you may be asked to write a ruling about maybe something to do with an interlocutory application. Remember interlocutory application, or rather injunction. You remember about the injunction, the three factors that must be there. You remember the issue of prima facie, irreparable, the damages, or balance of convenience. So those are the things, like, as the marker will be checking on your side. Does the student understand that in determining this issue, those are the factors to consider? If you're told about, you're given an issue about, let's say, for example, not really adverse possession, have you discussed those factors? Like, are they present? Like, you're supposed to discuss, for example, have an issue discussing whether there was consent to the entry into the land, whether there was, for example, land being possessed without, or in notorious, such kinds of issues. So it is just like you're identifying which issue you're dealing with, then, or rather which case you're dealing with, and what issues to be dealt with, so that you dispense with the main issue. And that will be all about the ruling or judgment. Thank you. Back to you, Angelo.
Okay. Thank you, Esbon. Is one of the facilitators this evening. So you realize even we have not colluded, but he has pointed to the aspect of structure. Very, very important. So as long as you say that you want to concentrate on the content, the appearance of the document that you are drafting is equally important. Please put that in mind. And as we conclude this one, I believe this will be the last aspect of our drafting for tonight. So you realize in any paper that you will be attempting, either civil or criminal, you will have at least two drafting. That we had it in question 1 and now in question 2. So the next one, maybe you will realize some people are going to draft legal opinion. If it is LWD, you will be required to draft it actually. You design what. But here now you are giving advice from the next one. But if we are told to draft a legal opinion, maybe we'll do it. So, and having said that, so please know in any examination, that is civil litigation exam, you have at least 2. So, and if you are good in drafting, so you have close to 30 marks in your pocket, or 20 at least at the minimum, okay? So that make your work really, really easier. Imagine you already have your 30 something or 30 oral plus project work, and now 20 marks in drafting, okay? So they really make our work easier. Please endeavor, try to perfect that one. Speed is very, very important. Let's go to number 3 very quickly. Tafadhali, our DJ Otieno, please. So let's have another one. Esbon will take you through this particular question, and I will equally contribute.
Can I read?
Yes.
Okay, can I read?
Who is that?
This is Bernard.
Okay. Then for someone Akinyi, you will answer. Yes, read please.
Okay, thank you. So the question 3, 2023 March reads: the Kenya School of Law has introduced a tutorial program in its advocates training program. Under this program, students are allowed to lead discussions in class on various themes in the curriculum. The students who lead discussions in the tutorial program are called lead discussants. Admission into the tutorial program as a lead discussant is highly competitive. Over time, it has emerged that students who graduate from the school having been certified as lead discussants are highly sought after by employers in the legal sector. Students must prepare very persuasive presentations under specified themes to be permitted to lead class discussions under those themes. You desire to lead the class discussion on constitutional litigation. The course instructor has directed that the first class in constitutional litigation will focus on the sub-theme, italics, entry points in constitutional litigation in Kenya. The lead discussant is expected to thoroughly examine the Constitution of Kenya 2010 and specify avenues in the Constitution through which courses may be taken before specified courts seeking application or interpretation of the Constitution. For purpose of this discussion, an entry point in italics is a point of provision, is a provision of the Constitution that vests jurisdiction in a specified court or courts to litigate a specific subject matter under the Constitution. 20 students have expressed interest in leading this discussion, but the course instructor can only allow 1 student to lead the discussion. He has therefore set high standards that a presentation must pass for the author to be considered as a lead discussant. You're among the 20 students that are interested in this opportunity to be a lead discussant. Discuss 5 avenues in the Constitution of Kenya 2010 that provide a basis for litigating constitutional questions, specifying the subject matter that can be litigated under each avenue, and the courts to which that avenue will lead the litigation lawyer filing the cause. 10 marks. Thank you.
Thank you so much for being eloquent in reading that particular question. Esbon, maybe you can now start with Ouko, Akinyi, and the rest.
Okay, thank you very much. Can I be heard?
Yes, you can be heard. Proceed.
Okay, so I'll use the FIRAC rules. So, IRAC. So issues
we've been asked to enumerate the various parts of the Constitution that one can rely on while approaching the court with regards to litigation. So just to be direct to the point, for me, I'll mention Article 22 of the Constitution, Article 23, and also Article 159 2D. So about Article 22 of the Constitution, it gives all courts the power to listen to any matter brought before them, and they have the discretion to decide on that matter. Yeah, so, and then Article 23, it gives every citizen of Kenya whose right has been infringed to approach the court through that article. So if your constitutional right is infringed, then you can approach the court through Article 23 of the Constitution, and this power vests in every citizen of Kenya. And then on Article 159 2D of the Constitution, it says that all courts have the power to listen to all matters without due regard to procedural technicalities. This means that the courts should not let procedure overpower substantive law, such that, for example, if somebody files a document out of time, then the case should not be automatically dismissed. Therefore, procedural technicalities, maybe filing late, for example, or without leave of the court, should not automatically lead to the dismissal of a case, unless it is a case that is an abuse, vexatious or abuse of the court process. So those are the articles that have come in my mind right now, just as